Scientist scheme. In the last 2 years itself, there are 400 women who have availed of that. They give about, I don't quite remember the number, I think somewhere between 5 and 25 lakhs of grant to women researchers who want to research in the field of science and technology. There are a lot of mobility schemes that have been launched by the government where women who travel and change cities because of their marriage or whatever reason are still getting employed in other government research organizations. There are women incubators that have come into the picture. As far as patent is concerned, there is an expedite patent examination process that has been initiated recently, like as it's a 1-month-old news, for any women applicant. So if a woman applicant files for a patent, she can get an expedite examination of her patent. So within the patent process, which usually takes about 4 or 5 years, within a year or so you can get a patent, which could be a huge boost for women when it comes to their own enterprises. Industry initiatives, as I said, the DIPP startup program we saw, there were, if 41% of 15,000 startups actually contribute to inventions and go ahead and file patents, maybe in the next 3 or 4 years, we'll see a change in the patent landscape. We'll see more and more women filing for patents. I think it's a good exercise to do it every 2 years to see how much these initiatives are impacting patent filings, which I will plan to do. And then the thing that's relevant for all gender imparity problems is the social initiative, to create an awareness, to change the mindset of people in terms of the fact that, okay, women can also, see, I feel the first graph that I showed where women are going into vocations other than science when it comes to higher education is because of this mindset where the woman herself feels probably she's not made for science. It's a very deep-rooted gender discrimination that has happened where people feel, okay, women, it's easier to do this, machines don't hang up, like that kind of a thing. But if we have more and more women that add to that 1% that of senior roles, we'll have more and more women making significant contribution to science and technology. We'll have more and more women who are inspiring tomorrow's generation. We'll have more and more women who are mentoring tomorrow's generation, where science and technology could be considered as a very good option for girls to get into these vocations. So on that note, I think I'll end my talk. If you have any questions. I don't know how this is switched off. So I just hand it over to them. Kalyan is also a loudspeaker, so.
Alright, good afternoon everyone. I think the cliche continues. So, see, I come here to talk to you about inclusion of persons with disabilities in science 1 week after a Supreme Court judgment. The Supreme Court a week back said that persons who are completely blind cannot become judges. And they came to this conclusion because persons with blindness cannot do certain strenuous acts and duties. And what are these strenuous acts and duties? Reading and writing, communicating verbally and non-verbally, advising advocates, taking evidence, following procedures. So, this is the attitude of the highest court of this country. So, we are talking about a court with a particular attitude, and it is in the context of this attitude, which is not just a reflection of the court's attitude, but also a reflection of the attitude of our society today, that we need to look at persons with disabilities in science. Professor Arul initially spoke about open science, and his definition of open science has many facets. But what I am concerned is with respect to open access. And open access to the extent it is relevant for open data and open publications. And open data and open publications to the extent they are copyrightable. Only a small portion of data is copyrightable, while most publications are copyrightable. So what I'm going to talk about is applicable to the data to the extent it is copyrightable and publications. As it stands today, this is applicable to all data and publications, not just scientific data and publications. Less than 1% of data and publications is accessible. Now, in order to change that, what do we need to do? We need to convert the data and publications into accessible formats. Now, if you have to convert something that is copyrightable into a different format, then you are violating the copyright owner's rights or copyright owner's copyright. That amounts to copyright infringement, right? So there is a fear among people that if I do something with a copyrighted work, then I can be held liable for copyright infringement, right? And therefore, most people would not, even if they do want to do it, convert data and publications into accessible formats. Oh, when I was studying in the mid-90s, when I was doing my bachelor's program, some of us wouldn't care about this copyright infringement. We would still convert it because we needed data and publications to study, right? But the same attitude was not there among faculty, same attitude was not there among librarians, because they had the fear of copyright infringement. And because of this fear, a lot of data and publications was not converted into accessible formats. Now, to address this problem, Marrakesh Treaty came into being. Now, the objective of Marrakesh Treaty is to incorporate a limitation or an exception in copyright law, which will make converting works into accessible formats for benefit of persons with disabilities not copyright infringement. So once it is not copyright infringement, the idea is that a lot of people would use that limitation and exception in the law to convert data and publications into accessible formats and make them available, as a result of which that less than 1% of accessible data will improve. This treaty came into being in 2013. India was the first country to ratify it. It came into effect, or you can say it came into force in 2016 after the 20th state ratified the treaty. However, this was not, 2013 was not very relevant for India, because in 2012 itself, 1 year before the treaty came into being, India amended its copyright law. And in the 2012 amendment, India had already incorporated an exception. And this exception permitted any person to reproduce, adapt, communicate to public or issue copies of works in accessible formats for benefit of persons with disabilities. So, if I have to put this very simply in non-legal language, what the exception said or continues to say is that if you want to use a copyrighted work and convert that work into accessible format for benefit of a person with disability, you can do that. And any person can do that for purposes of education, research, or personal use of the person with disability. So if you want to convert a work into accessible format for a person who cannot see, you can do it as long as it is related to his education, research, or personal use. Organizations, non-profit organizations working for persons with disabilities, or working for, let's say, for example, blind people, can convert it for any purpose, not just for these three purposes. If I need some materials and there's a non-profit organization, it can do it for me under this exception. So that was the exception that was incorporated under the Indian law in 2012. Now in 2016, the Rights of Persons with Disabilities Act was passed. This completely revamped the 1995 Disabilities Act. Right? This act actually made accessibility as a right. Under the copyright law, if I converted a work into accessible format, I was not liable for copyright infringement, but I still did not have the right to ask for accessible information, accessible publications. And this act made that a right. Under this act, government and even private establishments, under certain circumstances, are required to provide information, documents, communications, and publications in accessible formats to persons with disabilities. And if that is not provided, they can enforce it. They can go to court and say that their right to get information in accessible formats is being violated. So, if you look at it, the law is in place, right? We have the Copyright Act, which cleared the infringement problem. We have the RPD Act, which cleared the accessibility problem and made it a right. So how does it stand today in terms of accessibility? Has anything changed? Even today, the extent of access to information is less than 1%. As the proportion of information is increasing, the extent of access is decreasing. Right? Today, information is not accessed only through ABCD means. You have so many different means of accessing information, or means where information, sources where information is available. Right? You have a lot of sources of information, and you need this information. You need this raw material to be able to exercise your mind and make contribution, either it is in science and technology or any other field. Now, the situation is such that, I'll give you 3 examples of why it is like this as it stands today, or 3 examples of how it stands today, and then talk about why it is like that. Firstly, libraries. No library as it stands today that I have surveyed for purposes of this talk had a disability policy. Most of them have incorporated technologies and certain accessibility features in terms of physical access. They have certain reading softwares that can convert physical books into accessible formats. But beyond that, there is nothing that library is providing as an additional benefit to persons with disabilities. The extent of information as it stands today in libraries that is accessible or available in accessible formats is less than 1%. So if I want to go to a library and I want to read a book, I need to take the book, sit before a scanner, scan the entire book. Now the scan percentage accuracy as it stands today is somewhere around 90 to 95%. So take that book with 95% accuracy after about a few hours of scanning, and then go read it. If I want another book, I repeat the same thing. Right? So that is how persons with blindness and other disabilities are today accessing information. Secondly, patent database, which Vinita was talking about earlier, is actually a great repository of scientific information. Right? So because patents are filed with respect to inventions, if you want to know what's happening, what is the latest that's going on in the field, all you need to do is go to the patent office website and perform a search, and you get access to all these patent documents which you can review and understand what's going on. Right? Along with scientific publications, this has become a very important source of information. And this is public data. Once a patent is filed, it is published, and once it is published, it forms part of public knowledge. It is not in the public domain because patent term expires only in 20 years, then it enters the public domain. But it is part of public knowledge. And as it stands today, Indian Patent Database has a few lakh documents, right, which can be accessed easily by everybody except persons with blindness and certain other print disabilities. It is absolutely inaccessible. There are more than 90 problems on the Patent Office website in terms of accessibility. Same holds true with respect to the traditional knowledge digital library. Now, India always